Please be seated. So I have, I guess, at least two things on my radar, and then I'm happy to hear from you with regard to anything else that you want to put on my radar for movement forward today. So I think we can confidently say that we briefed the issue of Wayne, and by that I mean I have both the defendant's supplemental memorandum, and I've read it, of course, and the Commonwealth supplemental opposition to the Rule 17 OIIA records. I've read those as well. I'm happy to hear any additional argument that's precipitated by these new pleading or not, as you think is helpful to your case. So on that.
It's really nothing I could argue very briefly about some representation.
All right. I think the issue is fully briefed, but I want to give you the opportunity that if there was something that was raised by the opposition that you didn't get a chance to put in writing, that you at least had the ability. I didn't, you may disagree as to, your relative positions, but I just want to give you the opportunity to address that if you wish to orally. And for the Commonwealth.
We rest in the page, thank you very much.
No. So something on that. Can I see counsel at the side of the bench with regard to that motion for a second? All right. So then it looks like to me that you all made some progress, perhaps. Maybe that's wrong, but you made some progress on the Bode issue.
Yes, Your Honor. I think we made one step forward and one step back at the same time. The Commonwealth heard what you said at the last hearing, and I was able to work with my office to secure the funding for the defense's expert who was present during testing.
I saw that, and I appreciate your effort to eliminate issues where you can.
Thank you, Your Honor. Mr. Tipton was able to have conversations with Bode today and found out that they are trying to improve their facilities for experts to view the procedures. Unfortunately, they might be closed from April to September. So we are trying to get on a call today with Bode to find out when they would be not having experts there. My preference is to do this as soon as possible because we want this for the trial. So
run that by me again. So Bode is improving their facilities to enhance the ability of individuals to view, presumably because they're getting requests like ours.
And I think that Mr. Tipton can speak with far better than I can because he was able to get the email from Bode.
But they're going to be closed?
I don't think they're not doing testing. I think the facilities for the visiting expert would be closed from potentially April to September when they're doing these construction to build it out. So that's the problem.
Okay.
That's basically what I learned yesterday. And I'm a little vague on the details, but we have a vague email. So I shared it with the Commonwealth. And we announced in an email to a person in Brian Adam responded to me very quickly. I have a phone call, a joint phone call, where we better understand what he's saying. Yes, there's renovations going on for Bode and Tipton, and specifically there's renovations for the observation area that will improve observation. But it looks to us, or at least me, that it looks like the ability to observe maybe shut down for April. So we just need to get a clear opinion.
Are you in a position to get in there in March?
That's my hope is if we can get in there.
Then we avoid the issue altogether.
And I understand where the defense is coming from. They like the conditions. We have a trial date. I think that that's something we talked about as far as the cross-examination trial and whatnot. But I think that it's more of a trial issue right now.
That is the that. If I was trying to get clarification for both as to what the enhancements were, and of course our preference is to have the best, and I know that we're happy, we'll clear down they have that. So my understanding, Judge, was that the reading what we received from the Commonwealth about voting, the rationale for the charging of the fee they used, was that they could get the testing done in a matter of days. And I think I might be right about this, I might be wrong about this, and that's what we need to clarification for. If that means, yes, we get the testing, but that doesn't mean we're going to pick the court in 3 or 4 as to the results. So I was thinking, well, if the observation camps get ready to go the first week of September, and we were first in line, and of course all of this is presupposing, if we were first in line for September test, we would still get results and a report the first part of September, and it wouldn't disrupt the October trial. And
let me tell you, I need to know a heck of a lot more about those improvements before I'm going to put you off till September on an October trial day. That just seems to me to be a recipe for disaster, but delay. To be recipe for a delay to that trial date, and I don't think it's necessary. Now, I don't know the facts. I don't know what the facility looks like right now. Obviously, testing is being done there. Other entities are using them. Commonwealth has used them before. I'm sure that other people observe from whatever they have existing right now. And I'm certainly unaware of any case law or other law that says that it's been somehow insufficient or not adequate. for the defense to be able to observe. Felt that way, I wouldn't be sending down there in the first. So I'm going to start with the presumption that what they have right now is adequate for observation, and what we would get might be better, but I don't even know. They're changing the carpeting, I don't care. If they're making significant enhancements to how the observation is conducted, and those enhancements impact parking and the testing and work that needs to be done in our, it may be the case that the enhancements that they're making don't apply to the materials that we sent to the Commonwealth Center, that we have in this case, that are being tested by them. So let's sort that out, but I think you both should be prepared to get this testing done in March so that we can avoid any delay as a result of Bode's enhancements that, as of right now, anyway, I don't believe I don't think this situation in place is in any way prejudicial, as far as I know, to the defense. And nor do I know that anything they're doing to enhance their facilities is going to help us in any way.
In light of that, Your Honor, we had drafted, well, I should say, in light of this distinction, we had, before we knew about the renovations, I drafted an order for you for notice of defense expert, and
Let me see if I can put my hands on that.
I haven't copied it before.
Is that attached to your notice?
It would be attached to the notice, yes, Your Honor.
I printed out the notice they have, or they did it, someone got them. Has defense had an opportunity to look at the proposed order?
Right.
And before I read it, what's your, assuming that we can get it in March, what's your position with regards to the proposed order?
Well, I really don't have a problem with it. I mean, I don't know. I don't have a problem. What I do have a problem with it, I'm worried that our expert, and I'm waiting for more clarification. I don't think he's available. I think he's available in April. And I think if we get Bode on the phone and we can have a specific answer to a specific question and make it clear that when the observation is still being conducted before they stop doing it, then we might be able to have available dates. But that's the problem I have right now.
Well, the expert may be busy every day in March, but he might not have, every case isn't actually the same. That is, he may not be in a situation where Bode's renovations are impacting all of those cases, and I presume he's not. That is, said another way, maybe he can prioritize this case in light of the fact that Bode is going to shut down. Now, maybe they're shutting down on April 30th and we have nothing to worry about. And maybe they're shutting down on April 15th and he's free on April 1st. Who knows? That's what you got to sort out. But I don't know who your expert is. I don't know what his day-to-day commitment is, but that's what I'm counting on you to do. Go through day to day and see if you can shuffle some things around. In fact, Bode is shutting down at March 31st to see if we can get a day. We're talking about 1 or 2 days.
I believe so.
That's what it seemed like from what I was reading.
And you'll see that order doesn't have a date as far as when it's done.
Right, it's just that, probably in a phone call in 24 hours, you could tell me it's April 15th, it's April 30th. Don't worry about it, Judge. None of you worry about it. Got other bigger things to worry about than that, right? But keep on talking to the lab and get it back to me. Presumptively, I think that 2 weeks to let them know is good, but the thing is, I'm more worried about is the 2 weeks after that. If the close down is the 31st, I'm going to ask you to reach out to your expert and try to see if he can avail himself and make himself free for those days that we're going to need, even if it requires him to shuffle some things around.
And we're doing that. We will do that. I just want to make clear that the record, telling the court that we're doing all this, I don't want to be seen as waiving any arguments we've already made. I'm not going to make now about the lack of proper observation and how it goes into deciding whether it's certified. I'm not going to repeat those because the first thing we need to do is get all this information to make a better.
Okay, why don't we plan, just while we're on this issue, to have a Zoom call next Friday on this, so that we can close circle to see whether there's an issue or not on that. I don't need you to march up here, and if you want, I can get your client on a Zoom. I'm pretty lucky with that. But if you want to wait, all we're going to talk about is whether or not we've reached agreement with regard to this voting thing. But I don't want too much time, given that March is here.
We can do that. Next Friday is booked up for me until the afternoon.
We can figure that out.
And if you, between now and Friday, decide that you don't need to see me on this because you've reached agreement, you now know the information, and either you know that your expert's available in March, or Bode's not closing until, I'm making this up, till April 21st, and you can get them in before that, you don't need my attention, that's fine too. You can just email the clerk and say we don't need that. The only reason you need it is if you haven't reached agreement. So I don't know what time in the afternoon you're talking about, but I'm free pretty much the whole day. That day I'm not on trial day. I have another obligation, but I can hop on a call at any time. But I know that the facility gets hinky in the late afternoon, especially on a Friday, but it's hinky in the afternoon. Are you in a position?
I think from 2 o'clock.
No, but are you in a position to waive your client's appearance by Zoom if the facility can't do it later in the afternoon?
For that purpose, we
Just for that. And I won't talk about anything else. We'll just talk about whether we've reached agreement with regard to Bode, and if not, what we're going to do. I'll still try to get them on. I just know that at the witching hour in the afternoon, it becomes difficult sometimes to get them on later in the day. Usually in the morning and the early afternoon it works. I found less so in the late afternoon. What time's convenient for the two of you?
2 o'clock.
2 o'clock. So we'll do a Zoom hand, but we'll go forward if they can't get them on there for 2 o'clock. All right. And the third thing I have is this. Just give me 1 second. I did take a lot of notes on your motions, and I just want to make sure if there's anything that I want to have while you're here. Maybe this is a disconnect because I'm not understanding what's written in here, or maybe this is truly a disconnect. Among the attachments to the motion was a letter that was recently received by AUSA Moran, and in that letter, she says, and this is the second full paragraph on the second page, she says, my office previously produced to the Norfolk County District Attorney's Office copies of Trooper Proctor's statements made public at Ms. Reed's trial. Those copies are not subject to any protective order and therefore can be provided to Ms. Porges.
Yes, sir.
And then somewhere along the line when I was reading somebody's pleadings, I think it was the Commonwealth, but I don't know, maybe it was in the defense pleading, there was some discussion about materials that were turned over by the U.S. Attorney's Office but not used in the Reed matter that would be covered by the protective order. And that seems to be at odds with, it seems to me what AUSA Moran is saying is that if it was turned over in connection with the Reed case, it's not subject to the protective order.
We received 52 pages of text messages that were introduced to trial, Your Honor.
All of them?
No, 52 pages of text messages that were introduced to trial that were litigated at the trial.
Right.
Entered and read out loud. That was subsequent to the retrial. That was turned over to the Commonwealth, and we were allowed to turn that over to defense. And we did execute actually a protective order on that when we turned it over to defense, done without prejudice. There were 2 redactions, I believe, that we put on those text messages, and that was why we had the protective order. And I believe defense got to review the unredacted version, and we gave them a physical copy of the redacted version. So those are the materials that were turned over to us that this office believes was not subject to the protective order. The first batch, that 3,000 pages that the prosecutors in the retrial did sign that order for, that we have not deviated from. We believe that we're still held under that order.
So it's unclear to me as I read that. I mean, a reading of that sentence would be, she says further, my office previously produced to the Norfolk County District Attorney's Office copies of Trooper Proctor's statement. That's more than the 50 solid statements, right? Which would include his grand jury, would include any statements, right?
Yes,
But then just the sentence goes on to say, made public at Ms. Reed's trial. Those copies, is she talking about the copies of his statements, or is she talking about the statements that were made public?
we believe it was, she specifically mentioned the 52 pages, those copies of the 52 pages of text. That's what we believe, that because that was specific in a release to us as a result of a subsequent plea request that was done. That was turned over to us. And it wasn't by, and when I say us, Norfolk County District Attorney's Office, the Reed team filed additional plea requests, got with the authorization from the U.S. Attorney's Office. This was entered in trial, you can release this, and that's what we did. We did not receive the authorization from the U.S. Attorney's Office to release anything but those pages, and we turned them over to the defense.
Well, and I also note that as of February 12th anyway, the U.S. Attorney's position was that there was an ongoing investigation.
Yes, sir.
And I'm not sure if that's no longer ongoing, what impact it has on this request, if any. I mean, it's a litany of different things why they rejected, and perhaps beyond the scope of what we're talking about today, because that's presented to me in the context of the opposition to the internal affairs request.
Yes, sir.
But the basis for the rejection of the TUI request that you both made is a fluid analysis.
And I released an updated, my office received an update on that investigation. That was circulated to me via email by the person. I gave the copy of the information that emailed to counsel in a letter, yes. So if they want to use that for an updated TUI request,
I mean, there's still other issues that AUSA Moraine makes here in writing on behalf of the U.S. Attorney. But my reading of that letter seems a little unclear what position the United States Attorney is taking with regard to what information is covered and not covered by the protective order. Since we don't have the protective order, it's hard to know. And secondly, whether or not any of the changes in circumstance of that investigation changes their position.
Yes.
Thirdly, the investigation isn't going on anymore. I'm not looking for more work. There may be a preservation issue.
Okay, Your Honor.
I didn't want to put light according to it. I was having a conversation with another attorney on my way in on this hearing, and we're all waiting for an official, the U.S. Attorney. So we know if the investigation has that ends instead of just review everything. And then what you just said, that will propel us to file something in addition. I don't want to belabor today, but that's exactly what we're anticipating. We have a firm answer. Second is how it may impact on our dividends, how it may have some just to round us out. And I know Your Honor's going to make a decision maybe today, maybe tomorrow, maybe next week, but we're still waiting for, we might get it today, the production review by an independent review.
Right.
So if I may, Your Honor?
Yeah.
Counsel, that was one of the protective orders before, but counsel signed it, we've given him a copy of that review to them.
That's on.
That's on the drive.
Okay.
Attorney Sack has gone through, I believe, 8,600 of the 13,100, and then he's gone over several other portions of the phone and wrote about a 20-page report about that. My understanding through an interview that was done last night on a local radio station with the U.S. Attorney, Foley, is that U.S. Attorney Foley said that she cannot, under DOJ rules, confirm that an investigation has come to an end.
That's right.
And she said that it's not uncommon for law enforcement partners to be notified of the status of the investigation. My office was notified by the U.S. Attorney's Office. I provide that to defense. That's the best I can do.
By the way, I don't mind, I'm picking out and cherry picking portions of this letter that I just couldn't understand what it meant, and I didn't know if it was my lack of knowledge of the different parts or different parts of Trooper Proctor's statement, what was public and what isn't, because I have no idea what's public and what isn't, other than the emails that you see, everybody can see all over the news, okay? And that you pointed out to me in the pleading. But it seems to me unclear what the position of the U.S. Attorney is with regard to the statements that were produced. And I think a reading of that sentence is that whether they were used in public or not, what we turned over to you is not protected by the protective order with regard to his statement. I don't know that that's what they're saying, but I don't understand. But let me not forget the sentence before it, which is important, which they say, or she says, I'm not aware of any statements by state or local law enforcement in the possession, custody, or control of my office, the U.S. Attorney's Office, or the FBI that concern the investigation of Mr. Walsh for his wife's murder or the Walsh murder case. So unlike what was going on in the Reed case, there are no that she's aware that relate concern to this investigation, this prosecution. That's a very important part of this paragraph. So I didn't need to pick the rest of it off, but there's some lack of clarity there. And I now found out who it was, which is paragraph 46 of the Commonwealth's supplemental opposition. And that's when I wrote a note. Isn't this contrary to Moraine's letter? But maybe it's not. Maybe I'm reading it incorrectly. Footnote 13, Commonwealth's opposition defense ceding that is correct.
Is the Commonwealth's assertion in footnote 13 correct?
Yeah.
It is correct, and I take full responsibility for that. That is, when you try to edit down a 40-page of a pleading and you sloppily do it, what was excised from that turned out to be a 29-page pleading was a paragraph that explained my meaning of that.
But it did get brought up. I don't want to have to go back and read the whole thing.
It's just that the way that sentence reads, the Commonwealth's footnote that.
All right. I don't have any other meaningful footnotes. You've asked if you can advance and continue. And so I think the last time we were together, I moved your May 12th date, May 8th, 19th. Maybe it wasn't, maybe it was after I realized it. I don't know. But we're on right now for May 19th. I think I did it after. I didn't realize until after you left that I was still conflicted out because I was going to be somewhere else on the 12th. So Are you telling me you can get it all done in that one day, the 19th?
I believe, I mean, it could take 2 days, but the point is, what we're coming up with, Judge, is an overlap of witnesses, there's an overlap of
There
this,
is.
and it just started making sense to.
So when we had a discussion the last time we were in Dedham at the side of the bench, when I said I don't like 3, 4, 5 motions to suppress, you convinced me otherwise that it would make sense in this case. I won't repeat for the reasons why you indicated, but is that not a concern of yours any longer?
It's still a concern, but I still think that after we have been able to continue to process the information, that it just makes sense to bring everybody in and have a full hearing to address all of the search procedure and related issues in one hearing. There's no reason to call people and then call them back a month later. So that's what we're,
All right.
but we do want to say that it could take more than just one single day, but we would only know that once we got started.
All right. I'm just trying to adjust my calendar. So I'll block the 19th and the 20th. There's a chance I might not be here, but I'll stay tuned. I won't be far. And I think it's easier for you to come to my courthouse than go to them, only because then I have to kick another judge out of a courtroom, and that doesn't work. The only one that's available there is the little thing in the back, and that's usually not all that great for any kind of evidentiary hearing.
Okay.
That's remarkable.
What?
It was a jury of 6.
No, it was a jury of 12.
Wow.
That's never happened.
Only time I've been in there is for bail abuse. So for the 19th and the 20th, and then presumably, presumptively we'll be here, and I'll of course have the defendant caved in here. The fine for me on the briefing schedule. Anybody? Is this a joint? No, joint. Tom, will you fine with that?
The panel has no objection.
All right.
We do have one, I think, additional thing that is necessary for this hearing, and it might be appropriate to discuss in the sidebar.
All right. Today the 27th or the 28th.
Okay.
Thanks. All right. So next Friday on 2:00, and then the 25th, right? 25th at 9:00. All right. Anything else that anybody else wants to raise? No, seeing it.
Thank you, Ron.
All right.
Goodbye.